Hi everyone present. So today we have with us Mr. Shyam Agarwal. Shyam has been a JGLS student once for LLB, and after that he did his LLM also from here, and he passed out in 2021. And over to you, Shyam. Please first introduce yourself for our audience. Tell a bit about your career trajectory.
Yeah, hi Apurva. I'm really happy to be here and addressing students from the university. May I just ask you how many students are logged in?
So, Shyam, this is going to be, recorded as I had told
Okay.
you earlier, and then we are going to be posting it for everyone so that,
Oh, okay,
all the
okay, okay.
students can have a good
Understood, understood.
understanding. Yeah.
Just to give a brief introduction about myself, I completed my 3-year LLB from Jindal Law School in 2017. And thereafter I started practice. I worked in criminal law field for the first 2 years of my practice with Mr. Pawan Narang, who's now a designated senior advocate in Delhi. And thereafter I worked with an advocate on record in the Supreme Court, Mr. Yashraj Singh Diora, for 2 years. He's also now been designated as a senior advocate. And then during COVID, I used the time to do an LLM from Jindal in corporate and financial law. And then after that, I worked for about 3.5 years at the chambers of Mr. Dhruv Mehta, uh, who's a very renowned senior advocate in the Supreme Court. Uh, since about the last 1 year or so, I've been practicing independently. I started my own office last year, and I primarily practice in, of course, litigation and dispute resolution in the field of civil and commercial law, property law, arbitration, insolvency cases, and general civil cases.
That's really good to know. So, Shyam, my first question to you would be: so, what is the best part and the worst part of being a litigating lawyer in India?
So I would say the best part is that uh, the diversity of work is always there because work never gets mundane. You're working on different subject matters, different kinds of matters every day. So that keeps the work interesting. Also, the ultimate goal of any litigating counsel is to have your own practice. And that means that you are self-employed, you're the master of your own time. You're not, nobody is your boss, and you decide how hard you want to work. You decide your hours. So uh, I enjoy the freedom. And also, the most important thing is get, when you secure justice for your client, there's no better feeling than that. There's no better job satisfaction than that. Insofar as the bad parts are concerned, I would say that litigation has a very long gestation period. Uh, it takes time to make your mark and to become known before clients start trusting you and other lawyers start trusting you. Of course, nepotism is also a problem in our courts because uh, people who come from a certain lineage or a certain political background always have a slight advantage in terms of getting impaneled with government departments, etc., and building their practice, etc. Always comes a bit easier to them, but it can always there's no substitute for hard work, and if you work hard, then all those disadvantages can be defeated. Also, I would say that sometimes court delays get very frustrating. Uh, Everyone knows how overburdened our courts are. Waiting for your case in court, and the case is not reaching, or many a times nothing happens in the case. It gets adjourned for no rhyme or reason. So those are some of the frustrating aspects about litigation.
All right. So, for a law student, like a student who are just starting their course here, what should be the plan? Like, how should they plan their co-curricular activities, their internships, and their career trajectory if they want to be a successful litigating lawyer?
Yeah, that's a good question, Apurva. I would say that internships are very important. I think when I was in Jindal, we used to get an opportunity to do two internships in a year, once in the summer and once in the winter. So I would advise all students to definitely partake of that opportunity and definitely do an internship and not just sit at home or go for a vacation. I mean, you can do that as well, but definitely do at least a 4 week internship twice a year. And uh, of course, interning in offices which specialize in litigation, both civil and criminal, gives you a flavor of what litigation practice is like. So I think that's important. Uh, Insofar as what you can do in college, you should always moot and debate because that sort of hones your research skills and your public speaking skills. And insofar as yeah, it's very important to make friends in law school because those friends that you make in law school will help you in your career
Career
five,
as
ten
well.
years later. So it's important to have a strong alumni network. And I mean, the most important thing is that when you start out in your career, have the option of joining a law firm or starting in chamber practice. Both are equally good options. Law firms, of course, pay better. So I never worked in a law firm, but I would say that people who work in law firms also it helps them as well because you law firms typically work with big corporate clients, so you get to network with those clients, and ultimately, if you plan to start your own practice, those networks come in handy as well. I would also say that some trial court exposure is essential to
Okay.
understand how evidence is collected, how witnesses are examined, cross-examined, etc. So I would say that at least 1 or 2 years of trial court exposure is important for anybody aspiring to be a good litigating lawyer.
Also, I want to know, like, internships usually, what students feel. They feel they are not getting enough work, and the work that they are getting is sometimes they tend to feel that why should I do things that are not even related, which like things that I'm going to do later, it's not related to it. So how such feelings should be navigated? What should one have in mind when they are for their internships, and how to navigate from those mundane tasks that they don't like during internship? Because this is an experience that resonates with all the people who are interns, no matter where we go for internship.
Hmm. I can understand. You see, there's a lot of drudgery and clerical work involved in litigation as well. It's not all about good research and fancy arguments in court, etc. It's also a lot of, making indexes, putting documents together, all of that. So, yes, that can get boring. And of course, I've done it when I was an intern. We've all done it. But what I've noticed is that the reason why most lawyers give that sort of work to interns is because interns are too fresh or too new to be able to do anything else.
Yeah.
Unfortunately, because if you're in the first or second year of law school, you really can't be that much of an asset to any busy litigating lawyer. Uh, but having said that, I would say that if you do prove yourself to be a useful resource at any chamber or law firm, then I think any lawyer would be more than happy to give out research work or drafting work, etc. If they feel that you can take it on and deliver on time, because we are all running very short on time because nobody has time. There are so many cases listed every day, and therefore timelines are very important, and that's why I think most lawyers feel that interns won't be able to execute the work in a timely fashion, which is why they dish out all this clerical work to them. So but I feel if you prove yourself as a competent person, in your internship, then I think anybody would be willing to take additional help that you can give. At least I give my interns a fair bit of research work and drafting work. And any general student who's keen on doing an internship in litigation is most welcome to join my chamber.
Sure, thank you for mentioning that. So you have experience of practicing on both the civil and the criminal side of it. So what do you enjoy more, and why do you enjoy that aspect more?
Yeah, so I would say that I enjoyed my stint in criminal law as well, but I prefer practicing on the civil side for the reason that I find it is more challenging. Uh, there's a greater scope for legal questions and legal issues in civil law than in criminal law, because criminal law, as you know, is more about marshalling facts, and whoever is able to uh, uh, put across the facts and the evidences to the court usually succeeds in a criminal case. But civil cases, on the other hand, involve interpretation of statutes, etc. So I find that quite exciting. That's just my personal preference. Um,
No,
also,
that's a very
I
fair point. That's quite a
yeah,
fair point.
yeah.
Yeah.
Also, I feel that the ambit of civil law is wider because it covers many more subject matters. So, like within civil law, you have consumer law, property law, privacy law, service matters, labor matters, arbitration. So the canvas is much broader. So that's why I enjoy civil law more, because I feel that there's more diversity of work.
So, what are your views on the delays? Like, this is a very generic question, and this is for everyone, not just the lawyers. What are your views about the delays that we see in the Indian court system, and how do you suggest, like, what are the reformative policies or measures that we can imply and change this, the current
Yeah.
situation?
Yeah, it's uh, it's a problem that has partly to do with the fact that there are just too many litigants in our country, and people are happy to go to court at the drop of a hat, you know. Um, so the first thing that we say when some even the smallest thing happens to us is, I'll take you to court, or I'll sue you. You know, people go to court so easily in our country. That's also because at some level, I believe our country's population has tremendous faith in the Indian judiciary. But yeah, I think there are two, three aspects to the problem. I think one is we need to discourage frivolous litigation um, by imposing costs. So many of the cases I see, that are filed in the court are without any legal or factual basis, and in fact, sometimes many of the cases are filed due to malafide or just to harass the other party. So in those cases, if courts are more proactive about imposing costs on such litigants, uh, that would dissuade them from filing such kind of cases and would declog the docket of the court. That's one solution. The other solution is, of course, having more judges. I would say the problem of arrears is worse in the higher judiciary than in the subordinate judiciary. I think in the trial courts, in my experience, cases move much faster because there are many more judges and each judge has fewer matters listed on a daily basis. But in the high court, in many of the high courts, each judge has about 100 matters, 150 matters listed in a day, and it's humanly impossible to, hear each matter patiently and do justice in each matter. So I feel that, of course, we need to have more judges in the High Court. Many of the High Courts are functioning at less than 50% of their sanctioned strength, which is, you know, and that is why each judge is so overburdened. That is why so many matters are listed before each judge, because there are not enough judges. And the reason why there are not enough judges is because the process of appointing judges has become very complicated, with the collegium system, and many a time the recommendations made by the collegium are not accepted by the government, and the government keeps sitting on the file because they don't want to appoint the person who has been recommended by the collegium. So, these are some of the factors which are contributing to the delays. Ideally, what should happen is that even before there is a vacancy in the High Court or in the Supreme Court, the person who is going to replace or who's going to fill up that vacancy, the name of that person should be ready for appointment. But what we see is that vacancies continue for years on end before anybody is appointed to that post. And also, I would say that uh, it's very important to fix time limits. So what I've noticed is that in many of the courts, the final arguments, the judges keep hearing for days on end. And all the other cases suffer because of that. So judges should be more proactive about imposing very strict time limits, that all right, the petitioner or the plaintiff will get so much amount of time, 1 hour or 1.5 hours to argue, and the other side will get so much time, and not more than that. And I mean, if there are any further points, then that can be put in the written submissions. So that will save the time of the court, so that the court can hear other cases.
I have one point from your, all the solutions that you gave. You mentioned that you think that putting cost would be, a way in which people will not take each matter to the court. But then we have such gentry also who are, who won't be able to afford and probably, not then go for, because already they're paying their lawyers. There's so much more they are doing as it is. Don't you think, this might kind of inhibit justice in a manner? Like, this is my
So
opinion after hearing you out.
in my experience, most of the frivolous litigation is sponsored by rich litigants and not by poor litigants. It's the big corporates and the big law firms who are filing all these baseless applications and petitions,
So
and they can
you
definitely afford to pay.
okay. So you mean to say that there should be a cost once that the
Of course,
case
the
that okay
financial
after
position
that
of the
okay
litigant should be taken into account. I
okay
mean, the capacity of the litigant to bear
so
the cost will
yeah.
always be taken into account.
So that should be like a fine, like after going through
Yeah,
their entire.
yeah,
That is what
yeah,
you mean. Yeah, I
yeah.
think that is quite a valid point then. So also there is arbitration in India, right? Like for civil cases. And do you think it truly is a speedy and cost-effective alternative to litigation in the civil cases?
So, I would say the reason for why arbitration came about in the first place, why the Arbitration and Conciliation Act 1996 was enacted, was to provide a time effective and cost efficient way of resolving commercial disputes, because rather than as an alternative to the normal court process. But what we are seeing these days is that unfortunately, is that because of excessive interference of the courts in the arbitrations, even the arbitration cases are getting lengthened, just like normal civil suits. So what happens is that even once there is an award passed by an arbitrator, the the unsuccessful party challenges that award in the court by filing an application under Section 34 of the Arbitration Act. And typically, those petitions under 34 remain pending for five years, 6 years, 7 years, thereby defeating the very objective of arbitration. And in the meantime, the award remains stayed. So it essentially works out to the same thing. So what we what we definitely need to do is, and the court should be cognizant that the challenges to arbitral awards should be heard expeditiously. Awards should be set aside only in very limited circumstances, only if there is patent illegality, or if the unsuccessful party is able to prove any fraud or corruption on the part of the arbitrator. Otherwise, the sanctity of the arbitration process should be respected and the award should be respected.
All right. Also, I wanted to know about the insolvency and bankruptcy code. So, do you think it is a successful experiment by the government, like for the liquidation of the stressed companies, or you feel that the Sikh Industrial Companies Act was better, like under the Companies Act?
Yeah, so I think that under the IBC, we are seeing better rate of resolution of companies, revival and resolution of companies, than what we saw under the Sikh Industrial Companies Act. Because what used to happen under the Sikh Industrial Companies Act was that there was a board of financial reconstruction, and the companies which became sick under would continue remaining sick for a long period of time, and they would not and the pace of revival or rehabilitation of that company was very, very slow. The matters could would remain pending in the BIFR for a long period of time. And what happens is that the longer the company remains sick, the value of the assets diminishes, and so the recovery for the creditors is much lesser. So the most important thing in insolvency resolution is that it should be swift, so that the company can get back on its feet and the dues of the creditors can be repaid in a timely manner. So I think the IBC is definitely an improvement over the Sikh Industrial Companies Act, and we have seen that many companies under the IBC have been successfully resolved. Resolution applicants have taken over and are successfully running those companies, and the returns for the creditors are also better than under the earlier regime.
All right. So now I would like to change the subject a bit from law. So, what have been your fondest memories here at GGU? And okay, now again, I'll bring law into this also. So, as a JGU alumni, do you feel that students who study from here they have some edge over others? Like, first, you have to tell about the memories, and then about.
Yeah. So fondest memories would be performing at Biswa Meal and at Bollywood Night with my batchmates. We had a band and we used to perform at these events. And college gave us many opportunities to perform and showcase our talents, which was a very good thing. Then I was also a member of the Moot Court Society, and I did a fair bit of mooting. So we went for a couple of inter-college moots to Lucknow and to law faculty here in Delhi. So I really I have very fond memories of that. And of course, doing sports, etc., in the campus. We used to play tennis. We used to play cricket, etc., almost every day. So very fond memories of those times as well. And of course, I would say that the facilities for research in the university were excellent, because I used to spend a lot of time in the library, and we used to find whatever book we needed, we used to find it over there. And even the online resources for research like Westlaw and Hein Online, etc. The university used to provide all that, so it used to make our preparation for our moots and our research papers very easy. So I definitely miss spending time in the JGU library as well.
And about the second part of the question, do you think, like being a JGU alumni, you had an edge over others in terms of your career, in terms of your career?
Yeah, I think definitely, because the academic rigor that we are put through in JGU is, I believe, it's unlike any other law school, at least in India, because it's not just about excelling in exams. You are constantly tested by way of moots, by way of having to write research papers. Uh, so I think by having to write legal memos. So I think all that training really holds you in good stead when you enter practice, or even if you join a corporate law firm. Even today, whenever I encounter a case, what I learned in the classroom in Jindal always gives me a good background to approach the case in a holistic manner. So I would say that yes, it is a very, very good grounding and foundation, and it does hold you in good stead throughout your career.
Nice. And as we see, everything is turning, towards technology. We have everything on our phone. Earlier, we had different things. We had a calculator, we had a watch, but now we only have a mobile phone that is serving the purpose of everything. Do you think in near future there'll be a time where AI would be able to replace the lawyers?
No, I don't think so. I think this has
And why?
become
Why?
I I think everyone has become a bit over obsessed about AI. That AI can do everything. AI can replace human beings and destroy jobs, etc. But I feel AI is a good, useful tool. It's a good servant, but it can't be a master. And I'll tell you why. Because at least I'll talk about litigation, and because that's what I know most about. Uh, a very important part of persuading a judge in court is not just logic. It's how you put across the point to the judge. It's the emotion, it's the drama, it's the passion with which you argue your case. And I don't think any advanced AI can do that, do what
Yeah.
a human lawyer can do. And there's a very famous quote by Oliver Wendell Holmes, who was a very famous jurist in the US, that the life of law is not logic, it is experience. So cold cut logical arguments maybe AI can do, but it cannot substitute the abilities of a human lawyer arguing in the court. But
I
having
just,
said that, I would
yeah.
say that I do use some AI tools. Uh, uh, I use this software called Claude AI,
Okay.
which is very useful for quick legal research, as well as for drafting legal notices and even sometimes drafting pleadings. So those sort of mundane tasks, mechanical tasks, AI is very good at. So I would say that it's a good resource, but don't rely on it too much. Always do your own independent research, because even AI can go wrong. Many a times
Yeah.
AI can also go wrong.
Of course, we have Google Maps as a very good example. So many times we go wrong with that. But Sham, this is my opinion based on what you just told me. There was a time we never thought that our phone will be a touch screen. There was a time we had keypads. There was a time we had landlines. So you can never say never. Like, this is what I feel. Right now, they might not be that sensitive to data, or maybe really logic run. Maybe there'll be a time that they'll be able to catch those little things and read between the lines. We might reach that level. I this is like what I feel. It just came across my head while you were telling, you can't beat it, because there was a time when the technology that we had and now the technology that we have, it's very different. We did not imagine it like that. Being a 90s kid, I had never imagined I'll have a phone with a touch screen and
Hmm.
almost everything. Yeah. So
Yeah, but
also,
I feel that one these sort of topics or these sort of talks would discourage your law students from pursuing law.
no,
So we should be
absolutely.
optimistic about the future and think that
Yeah.
no, AI will not replace us, and
Yeah.
uh,
Yeah.
there will
Definitely.
always be a place for human lawyers, and I think they will. So
Yeah,
I mean, of
no, of
course,
course.
nobody can predict what happens in the future, but uh, this is just my perspective based on what I've seen.
If the technology becomes that good, then I think it's not just the lawyers, it'll be a total,
Yeah,
no job for anyone, not just lawyers,
yeah.
but so many other careers. Also, just the last question that I have for you is: isn't LLB enough being a litigating lawyer? Why do you think pursuing LLM is worthwhile? What is the difference and why is it important?
So I didn't do a foreign LLM. I did a domestic LLM from JGU itself, which was very good. I learned, I mean, I was not that thorough on certain areas of law like insider trading and securities law, etc., which I got to brush up in that LLM. So that was very good. But I would advise students to, if they can afford it, and if they if they have the means, to definitely apply for an LLM, because it really broadens your horizons. Many of my colleagues, many friends I know who are practicing, they've done LLMs from some of the best universities in the world, and I would say that it has helped them to a great extent, not just with respect to building a global network, but also understanding how other legal systems work, understanding how lawyers in foreign countries work, and also it gives you a perspective on how people live in other countries, and you get taught by the best professors in the field. So I think it really gives you a good competitive edge over other lawyers without an LLM. But I would say that you should do an LLM either right out of law school, or you should do it maybe 1 or 2 years after WorkX, because if you delay it too much, then you get too involved in your profession, you develop roots in the profession, and it becomes difficult to go out and take that 1 or 2 years off for your LLM.
But you still feel that it is important and one should pursue, even if
Yeah,
it is
absolutely.
domestic. Okay.
Even if it's a domestic LLM, you should do it, because uh, the see, education and learning is something that never goes to waste. Whatever you learn will, at some stage, maybe not immediately, but maybe 3 years, 4 years, 5 years, 10 years down the line, you will come across a case where what you learned in law school or in your LLM will definitely help you. So, and these days, having an LLM is considered a brownie point with respect to applying for various government panels to become an impaneled advocate, or even for judgeship. Having an LLM helps. So, I would say that if you have the time and you have the resources, definitely go for an LLM.
All right. Thank you so much, Sham, for your time. It was a
Thank you
good
for having me.
conversation. Yeah. And I hope the students will also learn a lot from this conversation.
Yeah,
And we'll like to have you again some other time. And that's
certainly.
about it. Is there any closing remark that you would like to add, either about JGU or about law in general?
So I would say that law is a very interesting field. It's extremely intellectually stimulating. It's very interesting, and I would encourage all students at Jindal to not give up law. Practice for a few years, and then make up your mind whether you want to do it. It's not necessary that everybody has to be a lawyer, but at least give it a few years and try it out before you give up. And I would say that the future is bright for lawyers. I think there is a huge demand for good, competent, sound lawyers, and I believe that there is a lot of opportunity out there. So I would say that all students at JGU must make the most of it. You're studying in an excellent institution. You're studying in a world-class institution, and your seniors and alumni are always there to help you and guide you. And you're most welcome to work in our chambers, intern with us, and any other help that students need from me, I'd be more than happy to help out.
Thank you so much.
Okay, thank you.
Okay, bye.
Bye. Thank you.